Okay, last section where we're going to be talking about duties to the client and our focus on costs. So in this hopefully pretty short section, we're going to talk about the things that are available, the tools that are available to lawyers who are chasing recovery of their costs. So what happens when your client doesn't pay? And now clearly there two key areas. So the basis on which a lawyer can recover her or their, I should say, professional fees and disbursements really comes out of the law of contract. But of course, because of the special nature of the relationship between the lawyer and their client, there is a statutory overlay that impacts that ability to recover. So it's the existence of the retainer between the lawyer and the client that substantiates the lawyer's claim for remuneration. And one of the reasons that we've spent so much time talking about the requirements for disclosure and the formalities for the cost agreement itself is that the uniform law effectively provides that if there isn't appropriate disclosure and the formalities haven't been required with, then the retainer will be void. And what happens when we have a void contract, void ab initio from the beginning? There is no contract. Accordingly, there is no basis on which the lawyer can sue. So let's get that out of the way to start off with. The retainer traditionally has been construed as an entire contract, which means, generally speaking, a lawyer who terminates a retainer without any cause or just cause forfeits the ability to recover costs earned to that point. So just basically terminating a contract, getting rid of your client, and then expecting to be paid in the absence of contractual right to do so is a very difficult position. And the uniform law restricts the lawyer's ability to enforce the contractual claim for costs in a range of different ways. So how do lawyers make sure that they get paid? The main way that a lawyer can secure recovery of costs is to essentially ask the client to pay up front. So the lawyer secures payment by getting the money up front. They hold it in trust. I'll talk about trust accounts in just a minute. Basically, that means that they've got the money, even though it's not in their bank account, they're not earning interest on it at this stage. They know in advance that they're going to get paid. And that is the most significant way, or the most common way, that we see lawyers secure their right to get paid. Of course, we also need to talk about the alternatives, but we'll get there. So in relation to trust accounts, take a look at Del Pont, Chapter 9. I think for some reason thinking about studying trust accounts feels scary. Don't worry, there's no numbers involved for what it is that you need to do. But I think Del Pont is actually pretty straightforward. Most of the case law that revolves around trust accounts is really around fraudulently accessing or inappropriately accessing money that is on trust, which clearly is a breach of the duties of loyalty and our duties to our clients, but may also be a crime as well. I think what's important here for our purposes, you need to understand who can receive trust money. So in other words, basically only a properly qualified law practice can receive trust money. So that is a law practice that has a principal or a legal director who holds a practicing certificate authorising the receipt of trust money. Approved clerks can also receive trust money for legal costs for one or more barristers. So if you are an employed solicitor working for a company, for example, you cannot take money on trust. The terms of your practicing certificate will not allow you to do that. For most principals of law practices will have those permissions on their practicing certificates. What is trust money? Let's think about that. Trust money is, for a law practice generally, money that's been entrusted to the law practice in the course of or in connection with the services that they provide. So it can include money that's received for legal costs in advance of providing the services. It could include controlled money that's received by the practice, so money that's subject to a written direction to deposit into an account or to be held for a particular purpose other than the general trust account. It can also be what we refer to as transit money, so money that's received by a law practice subject to instructions to pay or deliver to a third party. So, for example, the money that's going to pay for a property or money to pay for settlement of a dispute when the solicitor will be authorised to pay that money to the third party when all of the requirements are completed. What's really important actually is to also focus when you're reading Del Ponte on what isn't trust money. So trust money doesn't include money that's been received for the payment of your invoice, for example. That shouldn't be deposited into your trust account. It can be taken from the trust account to the general account, but money that is paid by the client for your invoices, if it's paid directly for the invoice, needs to go to a separate account from the trust account. Money for financial services that are provided, so money that might be entrusted or held by a law practice for or in connection with some financial services that they provide or that are provided by associated entity. So, for example, mortgage providers needs to be held separately from the trust account money. And money for managed investment schemes and mortgage financing schemes is not trust money, so it needs to be dealt with separately. The QR code will take you to the Legal Practice Board and Commissioners web page that deals with trust money, and that will give you a really good kind of understanding of the kind of things that lawyers are looking at when they're looking at a trust account. Okay, so as I have mentioned before, the uniform law and equivalent statutes in the non-participating jurisdictions prohibit lawyers from commencing proceedings to recover costs against their clients, so in other words, to sue under the contract until a bill has been delivered, and if that bill is a lump sum bill and the client has requested an itemised bill, then basically another 30 days after that. So you need to submit a bill. If that bill isn't itemised and a request is made for an itemised bill, then there's another 30 days. The QR code on the screen will take you to the Law Society of New South Wales website page for lawyers about client costs settlement deeds. In the case Koutsoudaris, I bet I've pronounced that incorrectly and apologise to my Macedonian and Greek friends out there for that. But I'll say it again, Koutsoudaris and Metledge and Associates. Probably the key case in this area, discussed in Del Ponte, in that Justice Hodgson has set out the factors which point to the circumstances when executing or entering into a deed of arrangement with a customer or a client will be considered to be effectively in breach of Section 194, in other words, taking legal action before the time periods have been completed. So the background to that case is there were the law firm had two clients. They had entered into some sort of cost arrangement. Clearly the bill wasn't paid, and the law firm entered into a deed of accord and satisfaction with one of those clients who still didn't pay, so they sought to enforce the deed. So the question for the court essentially became, was suing on that deed essentially a form of acting in a way prohibited by Section 194. And ultimately it was found for two reasons that it was. So firstly, the amount under the deeds that the client had agreed to pay under that deed was exactly the same amount as the cost claim to start off with. And secondly, the entity that was identified as liable for the whole amount was one of two of those entities that previously had been liable for the whole of the cost. Even though you couldn't tell what shares it was, essentially the deed of settlement, in this case it was called a deed of accord and satisfaction, was entered into by the client, promising to pay the full amount of the cost, and that deed was entered into before the time period had elapsed. So the justice said in that case, these two factors are present in this instant case. The amount claimed under the deed is the precise amount of the legal cost outstanding as at the date of the deed, and the parties against whom it is claimed are the parties who were previously liable for those costs. In other words, there's no real difference. So in substance, it was found to still be the recovery of costs that was sought in the proceedings. Section 194 said you can't do that without providing an itemised bill. So sorry, Metledge and Associates, you're not getting your money back. So what is this cost assessment process? Basically, it is a process. It's a process where an independent cost assessor, this is generally somebody who is an official appointed by the court, employed by the court, and they assess the bill for fairness and reasonableness, which we spoke about in a couple of videos ago. And so they do this when the client or the losing party complain about the costs. So the cost assessment process is there to correct overcharging when complaints are made. Though, to be fair, complaints usually only come after the client relationship has already been damaged to the point of no return anyway. So it is very rare to see actions that are brought against lawyers in relation to costs, discipline in relation to costs only, because there's usually a breakdown of the relationship and a whole lot of other issues that happen as well. In addition, the assessment process itself is quite expensive and somebody's got to pay for it, right? So often it's at the cost of reducing the total net revenue available to the client from the matter, and it ends up further souring the experience for both the lawyer and for the client. Again, so that you know it's available, sections 199 and 200 deal with cost assessment and the factors in a cost assessment. And also 201 is relevant because it sets out the reasons that the cost assessor needs to give. So as a matter of general law, it's long been recognised that it's important that lawyers have some security for their costs. And this is because otherwise lawyers would, the concern is that they decline retainers from anybody who had lacked the financial capacity to pay the fees in advance. I should be on the next page here. I'm already going on to the alternatives. It is appropriate, and the statute allows for alternative security to be obtained. So again, the QR code on this page is going to take you to New South Wales Uniform Law Resources in relation to liens. And really at this point, all I wanted to do is highlight some of the key factors. So firstly, what is a lien? A lien is a right to keep the client's property until the client has paid all the fees and the disbursements that are owed to the person who holds the lien. So in this case, we're talking about solicitors' liens, but liens are available in a range of other circumstances where somebody might be owed money and a person has access to or custody of goods or property that belong to them. A lawyer can claim a lien even when a client has paid a substantial amount to them already and only a small amount remains unpaid. So it's a very powerful weapon, let's call it, in the arsenal that solicitors have or lawyers have available to them. They tend to be referred to as general liens because they extend to all of the costs owed by the client, and they're not just restricted to debts that relate to the particular goods that are being held by the lawyer. Some of the tricky stuff around this is looking at what kind of property the lawyer can actually hold on to. So it's well established that if a lawyer is exercising a lien, they can hold almost any kind of property that they received while representing the client or that they developed. So that can include papers, deeds, other documents that are contained in the file. It can extend even to documents that the lawyer has received for other work that they've done for a client in other capacities, even if the client has paid those bills in full. It is usually, however, quite difficult for a lawyer to claim a lien over title deeds for a property if the property is passed to another owner. So it can only extend to property that actually belongs to the client. Wills. Passports are a really good example because a passport technically doesn't belong to the client. It belongs to the government that issues it, and it's held by even though I call it my passport, technically it's owned by the Australian government. And so it can't be held that way, but a lawyer can hold on to money, for example, that is being held on the client's behalf. So practically, what does all of this mean? A lien most commonly arises when clients change lawyers and the former lawyer claims that a lien over fees that are still owed. And this can cause a whole heap of problems for the new lawyer when they have an ongoing legal issue or a court proceeding and they need the file, they need the documents, they need to know what's going on. So there are a range of guidelines which allow files to be returned under certain conditions, and the conditions include when the client provides a reasonable amount of security in exchange for the file or for the purpose of the ongoing litigation. The new lawyers can also give a promise, or we call it an undertaking, that they will return the file to the former lawyer when the proceedings have ended. Although at the end of the day, when the proceedings have ended, it rarely matters to the client terribly much. So this tends to be a significant issue, and that will bring us into what we're going to cover off next for the rest of this week. And we will talk a little bit more about the duties that we owe to other practitioners. And I'll see you shortly to talk about that. Cheers.